This is Barry Zellma speaking for Claim School Incorporated's blog, Zellma on Insurance. Today we're going to talk about why fraud sufficiently alleged against agents and life insurers require the case to go to trial, and where a court limited a very lengthy decision to decide only that a case can go to trial by keeping it simple, which is really what every lawsuit should be. In Todd F. Stevenson, an individual et al. Versus Massachusetts Mutual Life Insurance Company et al., and dozens of other people, the United States District Court for the District of Montana, Missoula Division, on August 13, 2025, dealt with allegations by the plaintiffs, various claims including ordinary and professional negligence, negligent misrepresentation, breach of fiduciary duty, statutory violations, constructive fraud, actual fraud, fraudulent inducement, unjust enrichment, punitive damages, rescission and restitution, and a claim for an accounting. A rather extensive lawsuit. The claims asserted involved complex financial products and the alleged misrepresentations and omissions in the defendants regarding the stability and suitability of these products. Plaintiffs have alleged various claims, including ordinary and professional negligence, statutory violations, and other awful things that they claim were done to them by their insurance agents and their insurers. Under Montana law, punitive damages may be awarded when the defendant has been found guilty of actual fraud or actual malice. The Montana Supreme Court has recognized that allegations of agency generally involve questions of fact and therefore cannot be resolved summarily. To allege fraud with particularity, a plaintiff must set forth what is false or misleading about a statement and why it is false. Here, the plaintiff alleged that Gardner defendants encouraged plaintiffs to take an additional life insurance, including the Penn defendants' policies, and represented that these additional policies would keep the loan balance from getting out of control. Plaintiffs further allege that the representations and omissions of the stability of the tripartite structure were false because the structure was not stable nor suitable for the Stevenson's family's low-risk estate and retirement planning goals. The court found that these facts were sufficiently particular to state plausible claims for constructive fraud, actual fraud, and fraudulent inducement. Therefore, the Penn defendants' motion for judgment on the pleadings were denied. Under Montana law, punitive damages may be awarded when the defendant has been found guilty of actual fraud or actual malice. A defendant is guilty of actual malice if the defendant has knowledge of facts or intentionally disregards facts that create a high probability of harm to the plaintiff, and A, deliberately proceeds to act in conscious or intentional disregard of the high probability of injury to the plaintiffs, or B, deliberately proceeds to act with indifference to the high probability of injury to the plaintiff. A defendant is guilty of actual fraud if the defendant A makes a representation with knowledge of its falsity, or B conceals a material fact with the purpose of depriving the plaintiff of property or legal rights, or otherwise causing injury. Under Montana law, the defendants owe plaintiffs a duty of care. Taking the allegations in the second amended complaint as true, plaintiffs have pled sufficient facts to support plausible claims of relief against many of the defendants, and therefore the case will go to trial. In my opinion, insurance fraud is a tort that can be brought by the victims of the fraud who seek damage and punishment damages if the plaintiff can prove he was defrauded by his insurance agents and the insurers sold policies by the agents to the insurance. The plaintiffs in this very complex set of claims and legal issues resolved the motions to dismiss and has established that there were sufficient allegations of fraud that will allow the case to go to trial. We may never know because there will be no appellate decisions of what happens in the trial. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, it's free, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,150 blog postings. If you're interested in further detail about insurance, insurance law, and insurance fraud, please consider subscribing to my Substack publications for a very small fee. And please tell your friends and colleagues about this blog and these videos so that they too can subscribe. Thank you for your attention.